Well, thank you. That was a journey indeed. I live in Washington, D.C., and we have that beltway that goes around the nation's capital. They're going to use as a moat when all of us, go after them there. They're going to fill it with water. But this commute was really quite interesting. That Bryant Street thing, when you come off of Harrison and get on Bryant, I was there. I think I called about 4:22 this afternoon and said I was going to be there right around 6:15, and the GPS was right. It was about a 2-hour drive, 2.5-hour drive. So congratulations. Your traffic's worse in Washington, D.C., for those of you in San Francisco. Yeah, that's exciting. My name is Mark Mix, and it is a pleasure to be with you here this evening. And it's particularly a pleasure to be with you in California, because I used to live in Sacramento. I lived on 330 North Street, right down from the Capitol. I was here in 1987, 1988, working in Sacramento with then Tom McClintock and Gil Ferguson and a few other folks, names you may recognize, on an issue of compulsory unionism in California. And California, you have this reputation of being the leader. Sometimes the leader for the bad stuff. But I believe now California is turning the corner on the issue of compulsory unionism and is becoming a leader on the good stuff. And here's why I say that. Back in 2012, we had 6 state employees, one by the name of Diane Knox, who came to us in 2005 when ballot initiatives went up, taking away some union power. And union officials in Sacramento demanded that the state withdraw money out of even non-members' accounts, forward it to them for their political strike-back fund, and fund the opposition to those ballot initiatives in 2005. These 6 bold and brave state employees stood up and said they wanted their rights vindicated, just like Colleen, in the sense of a teacher being forced to pay dues or fees to support political causes which they oppose. And Diane Knox, we went to the Ninth Circuit, and of course at the district court we did okay. But for those of you who follow the court system in the Ninth Circuit Court of Appeals, how do you think we did? Not very well. But the good news from California is that most of the things that the Ninth Circuit Court of Appeals does, the U.S. Supreme Court doesn't like. And so if you have a Ninth Circuit Court of Appeal case and you're getting a writ of certiorari at the U.S. Supreme Court, there's a 67% chance that the court's going to look at that Ninth Circuit ruling and say, we might want to look at that again. And in the case of Diane Knox and the other employees that we were representing, the U.S. Supreme Court decided they wanted to hear that case again. And in 2012, they did. We argued that case, and 6 months later, the Supreme Court came down on the side of one individual, well, actually 6 individuals, but one individual with the name of Knox, and a case called Knox versus SEIU, and they decided that Diane Knox and the rest of the state employees in California who were not members of the union could never be compelled to pay this fee for political causes which they opposed. And the interesting about it, the court went a bit farther, understanding that this idea that government union officials can lobby the government, can redress the government, like you and I can do as taxpayers, which we're supposed to do. We're supposed to pay attention. This constitutional democratic republic that we live in requires that we be educated and that we be activated in redressing our government. But when you give a private organization who has the privilege of extracting dues money from someone, the privilege to speak to government, you're giving them power out of all comprehension of what our founders had in mind for how we redress our government. And the Supreme Court there, led by Sam Alito, said, this thing in California was wrong, and so we need to give Diane Knox and everybody else back their money. But further, we should go and we should look at this privilege that public sector union officials have been given. And there's no place else in the country, maybe perhaps Illinois and New York, where government union officials enjoy the type of power they enjoy here in Sacramento, in California. And the judge there said, this power that we've given them is so wrong that we need to look at it again. And they said, we're going to require that employees opt in to these things as opposed to opt out. And that is a major change in America's jurisprudence as it relates to compulsory unionism. Because previously union officials would say, we're taking your money, and if you want it back, you got to come get it. And you got to convince us that what we're doing is wrong, and convince us that you know what we're doing is wrong, and how much of your money we're spending, and how we're spending it, and the burden's on you to prove that somehow we've done something wrong to you. Well, the Supreme Court thought differently of it and said, no, Mr. Union official, you need to prove to these people before you take their money that they should be giving it to you, and they should opt in. And Knox opened up a door, not just a crack, but in a dramatic way, in a discussion over the power of government union officials in America and the power they've been granted. You know, we had a very, very good view of it in Wisconsin back in 2010, Scott Walker in Act 10. I mean, Wisconsin, ironically, was the first state in the country to really recognize union officials as bargaining agents for government employees. It was Franklin Roosevelt in 1937, in a letter to a friend who wrote him after they'd passed the national labor policy for private sector workers, asked him, said, why don't we do the same thing for government workers? This is a pretty neat thing, giving union officials monopoly power over workers. And Franklin Roosevelt himself said, we can't do that. We can't turn over the communications of government and the operations of government to private organizations like this. It's unthinkable we would do that. In fact, in the 1950s, the AFL-CIO Executive Committee, and then George Meany, the president of the AFL-CIO, when asked about government sector unionization, he said, our rights are equal to ordinary citizens to redress government. We need to organize and mobilize, and we need to have our voices heard, but we shouldn't ask the government to recognize us officially as the agent negotiating with government over taxpayer money. We don't believe in that. Today, the world is completely different. There was a brief period from October 2009 till about 3 months ago or 4 months ago where there were more government union members in America than there were private sector union members. Think about that for a minute. I mean, you have more government union employees in the country than you have in gross numbers than you do private sector union members in America. It shows you that government unionism is the final frontier for organized labor. It's the biggest money pot, it's the biggest place where they can have power, and it's the most important place where we need to address their compulsory unionism power. And Diane Knox and the 5 other plaintiffs there won that case in the U.S. Supreme Court by having the courage to stand up and giving us the ability to fight for them. And now 42,000 government employees in California got rebates. And the law of the land now is that unions must get people to opt into this type of behavior as opposed to opt out. Well, we thought that was pretty big cheese in 2012. But just about 2 weeks ago, we had a little bigger decision. I don't know if many of you followed it, but the last day that the Supreme Court was issuing decisions, they issued 2 cases. And generally, when the Supreme Court operates, they save the best cases for last, or the most controversial cases for last, or the cases with the biggest impact for last. And all of you can name one of those cases that came out on June 30th, can't you? That case was called Hobby Lobby. Remember that? And that talked about Obamacare and whether or not a private employer with sincere religious opposition to abortion and other issues could be forced to pay for this health insurance that Obamacare mandates on everyone else. Well, the second case that day was a case called Harris versus Quinn. And that was another National Right to Work Legal Defense Foundation case that we argued on behalf of a mother from Illinois, near Chicago. This mother, Pam Harris, and 7 other plaintiffs in the case, all similarly situated, takes care of her own son by the name of Joshua in her own home. Joshua's 25 years old. He's developmentally disabled. He can't take care of himself. And the state of Illinois has a program where, instead of institutionalizing these disabled people, that the Medicaid program provides a stipend to these folks to stay in their own home and being taken care of by their own parents or their relatives or friends or family. And in the case of Joshua and Pam takes care of her own son in her own home. And believe it or not, under a 2003 executive order by now imprisoned Governor Rod Blagojevich and an extended executive order by now Governor Quinn, Pam Harris was required to pay a fee to the union, the SEI union, to take care of her own child in her own home. Actually, Pam wasn't forced. She was under the threat of being forced. 3 of our plaintiffs in the case were actually forced to pay a fee up to about $800 a year in order to take care of their own children in their own home. You talk about an abuse of power. You can't make this stuff up. And union officials knew that they couldn't talk about the facts of this case. They couldn't talk about the fact that they were forcing mothers to pay union fees to take care of their own children. They had to say that somehow this public policy prognostication was so important to the survival of our country that the Supreme Court had not to take the case, had not to hear the case, and if they did, should decide it against mothers like Pam Harris. Well, unfortunately for the union officials, they didn't. This case came out of the 7th Circuit out of Chicago. We lost it in this district court. We lost it at 7th Circuit Court of Appeals. And the U.S. Supreme Court, we petitioned them to hear this case and let Pam's voice be heard and those of the other plaintiffs. And they conferenced this case 7 times. Now, for those of you who don't follow the Supreme Court that closely, What usually happens during a term of the Supreme Court is that all these petitions to be heard come into the court. Roughly between 8,000 and 9,000 petitions come to the court with saying, you must hear my case, there was an injustice done, you must write this. Well, the court looks at those 8,000 or 9,000 petitions, and each year they grant basically about 100 of those decisions. About 100. And what happens on a Friday when the court's in session is the 9 justices go into a room around a table. I've not been there, so I can't tell you exactly what happens, but there's no clerks, no staff, nobody there but the 9 justices. And the Chief Justice will hold up the case and say, who wants to hear Harris v. Quinn? And if you get 4 hands to go up on your case, you get granted an oral argument. Well, generally, most cases get heard. They talk about the case, and there's one conference on a case, and if they don't get the four hands up, the case goes away, petition's denied, and the ruling of the lower court is upheld, generally. Well, in the Harris case, this case was conferenced 7 times. We believe that this is a record for a case. They actually asked the state of Illinois to brief the case. They asked the United States government to brief the case because they knew the impact and the import of this power that had been granted to government union officials was so amazing that they wanted to be sure that they had all the information they could possibly get in order to consider this case of Harris v. Quinn. Well, after 7 conferences, and they finally granted the opportunity to have oral arguments, our foundation attorney, argued the case on January 21st of this year, and on June 30th, it was the case that was issued 15 minutes before the Hobby Lobby case. We had our, as Andy Warhol would say, our 15 minutes of fame. Because once the Hobby Lobby case came out, obviously that was the big issue of the day. And that's probably why you haven't heard of the Harris v. Quinn case. But in the Harris v. Quinn case, a 5-4 majority of the United States Supreme Court said that these people, even though the state of Illinois claimed that they were, quote, employees for purposes of unionization only, they didn't get vacation benefits, they didn't get retirement, they didn't get anything else except they got to pay this fee to the union in order to take care of their own children. They said they weren't employees of the state, and therefore this executive order, first executive order that forced them into this union, and then the state statute that forced them to pay unions, couldn't work for them, and it couldn't be applied to them, and they were free from compulsory unionism. Do you know where this scheme started, ladies and gentlemen? Where do you think this scheme started? Where do most bad schemes start that end up making it to the West? Exactly. This was Gray Davis, if those of you recall. Gray Davis and some shenanigans with the, yeah, right. He's the guy that started this, and it metastasized into about 18 states as we count right now. The Harris versus Quinn decision that we won 3 weeks ago now, we believe we can strike down these schemes in at least 15 states, probably 18 states, and it's expanded to not only personal care providers and health care providers, but to daycare providers. And we found out just yesterday in Washington State when a translator, an independent contractor translator who translates for the DMV, in order for him to continue to translate, he has to pay a fee to the union in order to translate up there in Washington State. So we believe this case will strike down the power of organized labor to collect fees from those people too. What we didn't get in the Harris v. Quinn case, though, which we were hoping for, and believe it or not, the case that may do this is coming out of California. It probably will make it to the U.S. Supreme Court next term. What we asked the Supreme Court to do was to consider the difference between a private sector union and a government union when it comes to compulsory unionism. We believe that compulsory unionism is wrong in any instance. No worker should be compelled to pay dues or fees to a labor union or private organization for the privilege of working in America. I mean, in a country founded on the grand experiment of self-government, where individual freedom and individual rights was the cornerstone of the foundation, of the bedrock of who we are and what we are, even though we've lost our way, I believe, on that. When you think about that, and you think that a private organization was granted the power to compel someone to pay them a fee in order to work in America, is an outrage. But since 1935, that's been the law of the land. And the National Right to Work Committee and the National Right to Work Legal Defense Foundation's sole mission is to end compulsory unionism in America. Yes, ma'am.
What about
Homeschooling, another great question. I'll get to that in just a little bit, sure. But our mission is to end compulsory unionism. We've done that through passage of right to work laws. Believe it or not, ladies and gentlemen, I want you to have hope today. If you walk away with anything else, walk with a full stomach of pizza, of course. But if you walk away with anything else, have hope. Because Michigan passed a right to work law in 2012. And if Michigan can do it, by golly, California ought to be able to do it too. Sacramento's a little tougher place than Lansing at this point, but But it is just unbelievable that over the last 2 years we've passed 2 new right-to-work laws. 24 states now say it's perfectly fine to join a union. It's perfectly fine to let the union represent you. It's perfectly fine to pay union dues if you want to. It's perfectly fine to support their political cause if you want to. But if you don't, you're not going to lose your job. That's all right to work is. That's all right to work was ever intended to be. Union officials know it's such a pervasive and persuasive argument that they've got to do something to deny it and change it and disfigure it and distort it because it's a simple matter of freedom. In many right-to-work states, I think in at least 6 right-to-work states, there's higher private sector union density than states that don't have right-to-work laws. Go figure. What are union officials doing in those states? They're actually providing services that workers want. And workers are saying, yes, I will pay you. Yes, I will join you. Just like you here tonight. No one was compelled to be here tonight. No one was compelled. We can't compel you to come here and spend your $10 on pizza. We shouldn't. But if you want to be here, please come. And if you want to be in a labor union, please do. And if you want to be in a labor union and be part of their political program, please do. But don't compel anyone to do that. That notion is wrong. So our litigation program is designed to address it. We're getting to a point at the Supreme Court, and I was going to finish the Harris story. What we didn't get was a decision that would say that no government worker in America should be forced to pay dues or fees. We almost, ladies and gentlemen, we were 1 vote away from actually getting a right-to-work law for all government employees in California. And I can tell you that would make a huge difference in the political marketplace in your state. There's no question the corrections officers and the state and AFSCME and the SEIU, those unions are just absolute huge political powers in the state. And the reason why they are is because they've got government-granted privilege that no other organization has. And we've got to get after that. And I would encourage you to keep that in mind as you look at all these other things, school choice, homeschooling, all these things. People have finally realized that the really only way to reform the educational system is to take away organized labor's monopoly power, their bargaining power and their forced peace power. I'll get to your question in just a second. Be glad to do that. And I want to take all your questions and answer all your questions because this is my passion in life, and I get excited about it, and I want to answer your questions. But the idea of freedom in America's workplace and that voluntary unionism is the default position as opposed to compulsory unionism is where we ought to be. And the National Right to Work Committee actively pursues new right-to-work laws. As I mentioned, Indiana passed a right-to-work law in 2012. Michigan passed one in 2012. Oklahoma passed one in 2001. And now 24 states have a right to work. In litigation, we have the Harris case. We have the Knox case out of California. There's another case that's not ours that's being litigated in California on behalf of teachers, a case called Friedrich, and is pending in the Ninth Circuit Court of Appeals right now, and it has a fast track, hopefully, to the U.S. Supreme Court. But that will call into question whether or not government union officials, everything they do is political. I mean, if you're talking to government, you are engaging in political speech. And so what the question on the table in both the Harris case and now in this extending case of Friedrich is, how can you compel someone to pay someone to speak to them to redress their government? It's a freedom of association issue. And we believe that the Harris case the Knox case got us to here, the Harris case gets us to here, and there's 3 cases of ours in this case out of California called Friedrich that will actually address the final question saying government union officials should never have this power. That everything they do is political. They're redressing government. They're asking for bigger budgets, more taxes, more regulations. They're lobbying government. And that speech is purely political. And you can't be compelled under the First Amendment to make political speech. So we believe the Friedrich case will take that, and that would be a national right-to-work law for government employees. Would California teachers be able to join the NEA or the AFT? Absolutely. Would they be able to allow the NEA and the AFT to speak to them? Absolutely. Would they be able to pay dues to the NEA and the AFT and have that money used in politics? Absolutely. But could any member of California's public service be forced? No. And that's really the secret of right to work. It's real simple. It's a simple concept. It's a really core issue for us and for our country and for what we believe in and who we are and what we are. And I would encourage you to look at right to work again, look at the issue of compulsory unionism, and if you're a school teacher or you're a public employee and you want to exercise your rights, know that you have a friend at the National Right to Work Legal Defense Foundation, just like Diane Knox did. Diane Knox and a couple of kindergarten teachers and a 6th grade teacher and a few others had the courage to stand up and fight. and we were able to take their case from the lowest levels of the court system in California to the steps of the U.S. Supreme Court, and they had their day in court and they won. It's a privilege to represent people like this with courage. It's a privilege to come out and talk about right to work. I grew up in a union household. My stepfather was a 32-year member of the International Association of Machinists. He was a welder. Walked the picket line with him in Dansville, New York, back in 1976. My mom worked in a school cafeteria washing dishes. She paid union dues. My brother's a fourth grade teacher. He pays union dues. We came from a union household. And so it's very difficult sometimes for union officials they call me a plutocrat and this kind of thing. And I don't even know what that means. But I guess it's bad. But it's been a real pleasure of mine to stand up for working men and women in America who want to have their voices heard, and had the privilege to do that. And then it's even a bigger privilege to come out and talk to you about it. Because what I see here today, and what I'm encouraged by, and what I'm encouraged by across the country, is motivated, highly intelligent, educated people who are engaged in the political process. And that's what we're supposed to be as Americans. We have an obligation to do that. No matter whether you're conservative, liberal, Democrat, Republican, progressive, whatever you are, you have a voice in government, and we need to exercise that voice. And I will tell you, as we travel across the country, we see groups like this, some smaller, some larger. We see them active, we see them involved. And that's what makes me feel like we're going to be okay in America. We're going to be okay. We've got to stay busy at it. We can't lose hope. That's what they want us to do. The other side wants us to lose hope in America and give up and throw up our hands and say we can't recover. Well, that's not who we are. That's not what we need to do. We need to keep fighting. And I promise you, on behalf of the 2.8 million members of the National Right to Work Committee and the 1.7 million members of the National Right to Work Legal Defense Foundation, that we'll keep fighting for individual freedom in America's workplaces, both here in California and across the country and wherever that might take us. It's a privilege to be with you this evening. I would love to answer any questions, and I'll leave it at that. I'll start right over here. He was the first guy. Yeah. Right there, huh?
I'm a 36-year union member. I enjoyed my union.
Yep.
My union doesn't represent me in my political beliefs.
Yep.
And I would say 60 or 70% of my union is against the liberals scanning my union chains. And I would say, knowing Rod and a couple of other correction officers, it's the same for them. They're not blanket Republican liberals.
Right.
The change I would like to see, if you can do anything through your foundations, or that we're represented through our values. It has to be, I'm giving my money and they're doing it against my will.
Yeah.
For something I don't support.
Yeah.
That I don't like, but I'm proud to have my union. I'm an operating engineer. Carpenters, they overdid stuff. They lost your union. You have to live within your means. You give a good product to the employer, and it goes forward. So I have a decent retirement, decent health care. What scares me is I have to pay for somebody's health care they didn't pay for, and mine's at risk because of it.
Yeah.
So there's all kinds of things.
They put guys like this in kind of that Hobson's choice decision. In American workplaces, even under American jurisprudence, he's forced with the question of do I defend my political rights or do I defend my workplace rights? In order for him to exercise his workplace rights, he has to be a member of the union to vote on the contract, to vote on union elections, to do these things that would help the union change its course and do the right things for their members. But if he wants to defend his political rights, if he wants to get out of that component that the union's spending on politics, which is, unfortunately, they get to adjudicate. They tell you what they spend or what they don't spend until you fight them in court, and then you have rights under a case we won called Back in the private sector, and a case called Hudson in the public sector, where a worker can get out of that political component. But in order to do that, he's got to resign his union membership. He's got to quit. And if he does that, he can't vote in union elections. He can't be a union officer. He can't attend union. He can't go. Well, he probably can go to the union hall, but it's not a friendly place if you're not paying your dues. He can't vote on the contract that's going to govern his very employment. So on one hand, he's got to give up his workplace rights to defend his political rights. In order to exercise his workplace rights, he's got to give up his political rights. It's really a question that it's a position that no worker should be put in. Unfortunately, until we end compulsory unionism, both in the government sector and in the private sector, individuals like that are going to have to make that choice. And it's not a choice they should have to make. What union officials always tell us, well, if they're so concerned about it, tell them to run for office. Well, unfortunately, in order to run for office, you've got to be a member of the union. If you're going to be a member of the union, that means you've got to pay full union dues. If you pay full union dues, they're electing politicians who are running contrary to your very belief system. So it's one of those things that it's just a choice that you shouldn't be forced to make. It's that choice. And so we continue to work on that. The secret behind the Harris case was that, for example, a government union in California that's lobbying in Sacramento, and you're part of that corrections officer union, they're really one of the really big, powerful unions. I remember when I was out here with Pete Wilson and Governor Gagmasian when we were working out here, they were big and bad, and I mean, I don't mean that in a bad way. I mean, they were big and they were powerful, and they were a big political force. But we will continue to work on the notion that, if the union can't force him to speak politically if he disagrees with what they're saying. And if we get that case, it looks like there's a 5-member majority in the U.S. Supreme Court right now for a very perhaps narrow window that would actually say that. And they've invited another case, that next case. Pam Harris and the 7 plaintiffs in the Harris v. Quinn case, they ruled them as not being government employees, so they didn't have to get to the bigger question of the speech. They said, well, we don't have to get. I think it was Judge Roberts again, believe it or not. I think Alito was ready to do it. It looks like Kennedy was ready to do it. It looked like Scalia was ready to do it, and Thomas was ready to do it. And we don't know this, but we think the Chief Justice said, well, look, we don't have to go that far to get to a good result in this case. Obviously, these people are not employees. Everyone recognizes that. Therefore, they can't be forced to pay fees to continue doing what they're doing. But we don't have to get to the larger question of all government employees like this, where we need to protect their speech rights and take away this privilege. This, what does Alito call it? This anomaly. He called it a First Amendment anomaly that union officials have this right to force him to speak politically. And that's, we hope we'll get there. Okay, right over here, sir.
Okay, this is a card check process. How does that affect what you're doing and right to work? And are you doing anything about it?
Yeah, he's talking about card check. And card check was a very, very hot issue back in 2010, 2008, 2009, 2010 when President Obama was first elected. There was a bill in Congress that would have basically taken away the right of individuals to vote in a secret ballot election in order to join or not join a union. The way the unionization process works today is this. You're in a workplace. We're all in a workplace right here. We're having a union hall meeting right now. And 30% of you, I don't know how many are in the room here. Let's say I'm a government school graduate, so I will say there are 100 in the room, okay? 30 of you actually sign a petition. It will make this easy. 30 of you sign a petition that say you want a union election. That petition will go to the National Labor Relations Board in Washington. They will look at it. They'll say, okay, we recognize this bargaining unit here at the Italian restaurant, the pizza shop, and we believe these 30 people have signed this petition. We will now go out and we will have an election as to whether or not the union that sent this petition in will be the exclusive bargaining agent for all of you in the room. And they will schedule a secret ballot election. And generally in about anywhere from 38 to 45 days, the government will conduct an election where you get to, put an X in a box on a piece of paper and put it in a ballot box and have your say in private about whether or not you want to be in the union or not. Well, the card check bill was designed to basically circumvent the secret ballot. Union officials have been very unsuccessful in winning secret ballot elections over the years, so they changed their tactics. And they use what's called card check. And over the course of the next 3 months, I'm being the union organizer. I'm going to come meet with you individually at your home, sometimes at your work, sometimes in the parking lot or the bowling alley or wherever we are, the Little League game, and I'm going to ask you to sign a card. And you're going to say, well, Mark, what's that card? I'm going to say, well, it's just an information card. It gives you more information about the union. Or we're going to help you get some more pay if you just sign this card. Or we'll help you get insurance if you just sign this card. Well, little did you know that by signing that 3x5 card, you now have voted for the union. And under the card check scheme, if I can get 50% plus one of all of you to sign that card, even though 49 of you have no idea I'm doing this, if I can get 50% plus one, 51 of those cards signed, then all of you are going to be in the union. That's literally what the legislation was going to do in Congress, the card check bill. And this has been the primary mechanism for union organization in the country over the last probably 15 years. Union officials want card check. Now, many of you may have heard about the Volkswagen plant in Chattanooga. There was a big issue down there. The United Auto Workers was trying to organize the first automotive manufacturing company in a right-to-work state. 72%, get this, 72% of all the automobile manufacturing that goes on in America now goes on in states that have right-to-work laws. 72% of all the automotive manufacturers. That's the original equipment manufacturers. That's the people that build the actual cars. All that goes on in states that don't compel anyone to pay dues or fees to a union. You got to keep a job. So the United Auto Workers Union looked at this and said, my gosh, if we're going to survive, we've got to unionize one of these plants. We've got to unionize BMW or Volkswagen or Toyota or Honda or Nissan or Kia. One of these plants, we've got to unionize them and get a foothold in the right to work states. And so they picked the Volkswagen plant because Volkswagen's management over in Germany has a much different attitude about this than usually North American or American management does. And so the UAW set out to get these cards signed. And over the course of about 2 years, they got enough cards signed. And one day they stood up in front of a camera and said, we have a majority of the workers who signed cards at the Volkswagen plant. And they were going to give them to the Volkswagen management. And if the Volkswagen management would have taken those cards, that would have been it. All the workers would have been in the union. They would have negotiated a contract. But a funny thing happened on the way to that card check election. A bunch of the employees called the National Right to Work Legal Defense Foundation. We signed retainers. We represented, I think, by the time it was all over, I think we represented 8 or 9 of the employees, but we had a group of about 600 that we were working with. And we filed an unfair labor practice against the United Auto Workers saying that the way they had obtained these cards was illegal. We believe, and there was stated testimony and sworn affidavits, that people were given tickets to amusement parks to sign the card. Cards were, we'll give you some money, we'll give you some of this, we'll give you some of that if you just sign the card. And they can't do that. They really can't do that. And so when we uncovered this, the UAW kind of stepped back and we said, well, if you have the cards, show them to us. Show them to somebody. Of course, they never showed the cards to anybody. They claimed publicly they had the majority, but no one ever saw the cards. And so then the Volkswagen management, a guy over in Germany, made a comment saying, if the workers of the VW plant won't unionize and pick the UAW as their bargaining agent, then we will not give them this new SUV platform, which, if you follow this closely, you know that Chattanooga got it on Wednesday of last year. 2,000 new jobs of $1.6 billion in new investments, and Volkswagen is going to build a new SUV down in Chattanooga, Tennessee. So obviously but when Volkswagen management said that, we filed an unfair labor practice charge against Volkswagen. And of course, the National Labor Relations Board, which is the 5-member board in Washington that adjudicates all of these issue disputes, came in and after about, I forget how much time it was, but they said there was really no big deal. But they did Volkswagen did announce that they would have a secret ballot election. And when they did, on February 9th, 10th, and 11th, the majority of the workers at the plant voted against unionization, and UAW lost the election. So they went from having a majority of the cards to having a compliant management to having the employees say something by secret ballot. And when they did, when they got the vote behind the curtain, they voted against the union. And UAW obviously was very set back by that. We still represent some of those employees. The union contested the election and filed complaints against the outcome, and so we continue to represent the employees. We filed another lawsuit against the UAW based on some things that they did and what management did with Volkswagen, and then they withdrew the charge after we filed our additional case. But that's kind of how the card check works, and that's the primary mechanism by which they try to unionize now. But believe it or not, there was actually legislation that was going to take away the rights of workers to have secret ballot elections, which is really kind of funny. I mean, interesting. Another question. Yes, sir.
Did you get involved with the Boeing movement?
We did. This is great. Another big high-profile case. For those of you who remember the Boeing case, they built the 787 Dreamliner. This is their new, big, kind of wide-body aircraft made out of ceramic materials. I think it's flying right now. I haven't flown on one yet, but I'm not sure I want to. But no, it looks like a very solid plane. They're flying it international now. They aren't flying domestically, I don't think, although Chicago may be having one. But the question was, Boeing wanted to build this airframe. They had back orders of about 825 aircraft, and they couldn't produce them fast enough. So they went to the International Association of Machinists up in Renton, Washington, and they said, we need to make sure we have a continuity of production here. We can't have strikes. Boeing had 5 strikes in 22 years, I think it was. One strike cost the company about $1.4 billion in revenue. And they said, we can't afford to shut down the plant. We've got to fulfill these orders. So we want you to agree that if we'll build the 787 in Renton, Washington, if you'll agree that we can have a continuous workforce for the period of our contract. And the IAM said, I don't think we want to do that. We're not going to do that, and how dare you ask us to do that. So Boeing went out to site the new production facility, and they ended up in North Charleston, South Carolina. And they invested about $1 billion down there. They hired about 1,000 people. They announced that they were going to build the aircraft there. They built the factory. For anybody who's been to Charleston, it's an amazing factory. They are now up to 6,000 employees, and they're adding space all the time. But the important point here is that not one worker in Washington lost their job. In fact, they expanded the production facility in Washington, too. They're building 787s in both facilities, in Washington and South Carolina. Well, the moment, about 3 weeks before they were going to cut the ribbon at the new Boeing factory in Charleston, North Carolina, the International Association of Machinists filed an unfair labor practice charge against Boeing saying that it was anti-union animus. They were just anti-union for citing this plant in the right to work state of South Carolina, because there was the union, there was no unionization down there, and they built this company, and so they filed a suit. And of course, the National Labor Relations Board said, they looked at this and said, we agree, this was a violation. We believe a complaint should be filed. And so there was a court process that was set up with an administrative law judge, the way it works. And the remedy in this case, if Boeing would have been found to have violated the National Labor Relations Act, they would not have been able to build the aircraft in South Carolina. Even though they'd built the factory, they'd hired people, they were within weeks of cutting the ribbon, they said you cannot produce that aircraft there if they had lost the case. That was the remedy in the case. And so we had Boeing employees that came to us, we represented them, we filed charges against the IAM, unfair labor practice charges. We actually were granted intervener status in the litigation. So because the employees, the company was on one side, the union was on the other, and no one was representing the employees, the administrative law judge allowed the Right to Work Foundation to represent the employees, and we were part of the process as to how the remedy would come out. So we ended up having lawyers that were involved in the case all the way through. Obviously, at the end of the day, it was the most amazing thing. I happened to be up in Seattle when the case opened, and the moment the administrative law judge gavelled in the proceeding, the Boeing representative lawyers and the union lawyers and the government lawyers all stood up and said, we want to go into executive session. They went into these rooms, and they spent like 4 weeks there. When they came back and said to the administrative law judge, said, we want you to just stop this case. And the administrative law judge said, what are you talking about? I mean, we have a case here. You want to settle? And he said, no, we don't want to settle. They said, well, do you want me to rule? He said, no, we don't want you to rule. Well, is there an agreement? No, there's no agreement. We just want it to go away as if it never happened. You can't make this stuff up. And sure enough, the agreement was, and although there's no written record of this in the, quote, administrative law judge arena, what they ended up doing was the union ended up agreeing to they got an extension of a contract in Washington State for the 737 aircraft, even though the contract wasn't up for another, I think, 10 months or something like that. The company agreed to extend the contract on the 737 airframe, and they dropped their charge at Boeing. Boeing's now building great aircrafts in Washington State, and they're building them in South Carolina. The South Carolina plant has not been unionized at this point, even though the machinist union's down there trying to organize. And if they can organize in a right to work state, more power to them. They can't force anyone to pay dues there, but they can actually represent workers if they want to. So, yes, sir.
Has your organization ever argued a case regarding project labor agreements?
We have been involved in them. In fact, we took over one case that was out here in California. The Associated Builders and Contractors was doing a case, I believe it was in San Diego, in Orange County. It's not specifically related to compulsory union, so it's a little bit out of our area of expertise. But he mentions project labor agreements, and this is a very interesting thing from a taxpayer standpoint. A project labor agreement usually is involved in a contract when a government entity, a city, a county, a state, wants to build a government building of some kind. Or, better yet, if they're involved in the building of a building, if there's federal money in it, or state money in it, or county money in it, they can say that we want to have what's called a project labor agreement. And PLAs are basically agreements that say, in order to bid on this contract, you must be a union signatory. You must be a union contractor in order to bid on this contract. Or you must be, if you're a non-union contractor, you must agree to all the union conditions if you're going to bid on this job. Well, unfortunately, for taxpayers, first of all, about 84% of all construction companies in America are not union. So that takes the pool of folks that can bid on contracts to build buildings down from 100% down to 16%, basically. And if you're a non-union contractor, generally you're doing work in the private sector, you're doing some work in the public sector, and so your wage structure is a little bit different. And if you agree to this, then all of your employees end up in the union, and they end up in the union for the project, and they never get vested in the retirement plan you have to pay into, and it's really not a good situation. But what's more important there is that we know, and studies have shown, that project labor agreements tend to raise the cost of all municipal contracts and government construction contracts by at least 15, sometimes 30%. Just by eliminating that bidding process and by saying the only people that can bid are those with union contracts. The litigation on project labor agreements, they've been upheld. I mean, basically what's happened in the litigation there is the courts have adjudicated that governments are market participants. And if you're a market participant, then the two parties who agree to this can basically say, yeah, we'll do whatever we're going to do. The government becomes like an ordinary market participant in the PLA projects. Some states have outlawed them. There's a very big push in state legislatures to outlaw project labor agreements. When George Bush was president, he signed an executive order saying that they wouldn't recommend project labor agreements for federal contracts. And as soon as Obama got in on February 11th, 2009, he signed an executive order saying that any project over $25 million of federal money should be a project labor agreement. So it's kind of like a tennis match now as it's going back and forth. But project labor agreements are another form of, by extension of compulsory union, because it says if you're a non-union contractor employee, you probably don't get a chance to work on these government projects. Again here? Okay, back here, and then I'll come back to you, sir. Okay, right here.
Yeah, just another segue to back rights. You don't always lose in that deal. In 1992, I claimed my back rights at a Teamsters job. I was working for a bottled water company in the Teamsters. I'm the son of a Teamster, but I in no way supported how the Teamsters uses their money politically. When I claimed my back rights, I begged, I pleaded, I took time off work, went down to the union hall, and spoke with the president directly. Please, tell me how much my union dues are. Because the only thing you get when you claim your back rights is a reduction in your union dues of that percentage of your monies that are spent on political activity. For 7 years, I worked a union job. I didn't pay no union dues. I didn't lose a thing. When I left that company, I had all of my retirement because that was provided by the company, not the union. Mm-hmm. I didn't vote in any of the contract agreements. I was predetermined before the members even didn't vote anyway. The union always get together with the company boys, they have feedback and say, hey, this is how it's going to be. And then the union reps come in and say, all right, boys, this is what you want right here. We got you. You wanted $1.50 an hour, we got you 12 cents. Signerson is a good deal. So I encourage everybody to tell, I know many of you are retired, but if you have children or grandchildren working in union jobs, tell them to look up the back rights.
Yeah.
You know? Make a statement.
Yeah. The case of Beck was a case that the foundation litigated. We won in 1988 in the U.S. Supreme Court. It was on behalf of a guy by the name of Harry Beck. He was a telephone lineman in La Plata, Maryland, and he found out in 1975, I believe it was, that his money, he was forced to pay dues as a condition of his employment, could not get out of it. He found out that his money was being used to support a candidate who he opposed, and he came to us. We took him all the way through the process. And at two intervals during the case, during the NLRB process, we had a special master assigned to the case to try to figure out what those union dues were. And it was very interesting because it was kind of the first case. It was that, that fret. Well, we don't talk about snow out here too much. But, the neat thing about the East Coast is when we get snow is that first time when you get to step in it, there's no steps in it at all. You walk out in the morning and you got 2 feet of snow and no one's disrupted it. The Beck case was our first real look at internal union finances as it relates to politics. And they, in two different instances in this process, in the Harry Beck case, the union could only prove that, in one case, they could only prove that 19 cents of every dollar that they took in as compelled could be credited to anything that resembled collective bargaining, contract negotiation, or grievance arbitration. Those are the three things that unions have been granted the privilege of forcing you to pay if you're in a union shop. You've got to pay for, quote-unquote, those three things. They can't charge for politics. So we had a case where 81% of everything they were spending could have been rebated to all the workers who would exercise their rights under Beck. Of course, the Beck case was originally designed to get out of the whole thing. The court said, well, we can't go that far, so we'll let the union continue to force you to pay for contract negotiation, collective bargaining, and grievance arbitration. Those are the three things you must pay for in the private sector. To your point, what we found in litigating against unions, and we have about 260 cases active right now. We're representing about 40,000 employees across the country. We've literally represented over 500,000 employees in various, since 1968, since we were founded. And what we found now is that when an employee usually stands up and makes the case, the union officials kind of judge them. Is this guy serious? Is he doing this because, or is he really serious about it? And if they find out that you're really serious, what they'll do is they'll give you all your money back because they don't want you to litigate. And oftentimes now, when the Right to Work Foundation files a lawsuit, the union will settle with everybody. They'll say, here, you get all your money back. Because they don't want us to end up in the U.S. Supreme Court in Harris v. Quinn. They don't want us to end up in the Supreme Court in Knox versus SEIU. They don't want us to end up in the Supreme Court in Harry Beck versus Communication Workers of America. Because every time we get a chance to go there, they find, and people get to get the real picture of what compulsory unionism does in this forced political conformity. They realize they're going to lose some of their power. So the less sunlight they have, the better off they are. But in your case, you can exercise your Beck rights in the private sector. You have what's called Beck rights. You can say, I want to exercise my Beck rights. The union will say, well, you can't. And you say, I know I can. And they say, you really can't. And you say, I know I can. and they say, okay, prove it, and you send them a letter, and the letter's on our website, nrtw.org. You can pull the letter right off that you have to write. It's perfectly vetted. It says everything you need to say, not more, not less. And then they'll say, well, we had one case where a guy said, well, your political dues are a penny. They're 1 penny. You'll get 1 penny back, and you gotta resign by certified return receipt mail, which costs like what, $4.50. So unless you really believe in this in principle, from a financial standpoint, it's hard. I mean, because generally you're not going to hire your own lawyer to do this at $150 or $400 or whatever, $1,500 an hour to litigate these cases for you, unless you can find the National Right to Work Legal Defense Foundation and have us do it for you. And once we do it, they'll usually let you out in its entirety. They won't push the issue because they'll worry that we'll litigate and we'll get more people involved in that. So, yeah, here, and then I'll come right back. I'm sorry. Well, go ahead. I said I'd go you first. Go ahead.
Okay, well, just a brief comment. Project labor agreement imposes the terms of a very rigid and flexible union shop agreement on the contractor without his participation in it, and removes a lot of his rights to manage. It's a very, very expensive process for the contractor.
Yeah, no question about that. Yeah, he's just making a point about these agreements that force these conditions on the employer and changes the way they manage their business. That's absolutely right. It's expensive. Yes, sir.
Okay. I'm going to speak in terms of a realtor, in a term that I understand.
Okay.
Disclosures.
Yes.
I see the union as a seller of their service. The employee is the buyer. And when the buyer buys a house, they get disclosures about that house. Mm-hmm. Now, in this case, the disclosure is about the political activity and the financial distribution of the money me as a union worker is paying to you, the union. Is there a disclosure that's published and mandatory that all employees can see to see what candidates they're supporting, what issues they're supporting, and what percentage of the money is going to politics versus the other three things you said, collective bargaining, etc.?
Yeah. Well, let me just say this, and this is, I've refinanced my house recently. I don't read any of that stuff, you crazy guy. And if I don't sign it, what? I don't get the note, do I? I don't get the house. You crazy. Anyway, it's a personal thing. I'm over it. Private sector unions are required by law to file what's known as an LM2 form with the Department of Labor. If they represent private sector employees, they got to file this form on an annual basis with the Department of Labor. It's called an LM2. That LM2 form, up until probably 1992, was simply revenue, expenses. That's all it was. Revenue's this, expenses are that. Here's the bottom line. This is what we had. There was no way for anybody who was interested in figuring out what they were spending. We recommended to then President George H.W. Bush, what is he? He was 41, is that right? I forget the numbers now. 41. He actually had a Rose Garden ceremony basically announcing new rules for back rights and postings of notices, and they did some work on the LM2 form. And what we tried to do, we helped to kind of guide them, is create what you're talking about as functional categories. So you could look at it and say, okay, administration, kegs of beer, political dues, rent, cars, jet planes, those kinds of things. We got some additional disclosure during the George Bush years, the W. Bush years. They tried very hard to reform the LM2s, and then it got thrown out again. So there's really no real clear, concise way of doing that. One of the things that we've ended up with litigation in our Hudson case and our Beck case was that we required an independent audit of the union finances. Of course, the unions objected to that. What they would do is send it out to the auditor for the union next door, and they would say, "Oh, everything looks fine," and that's not really right. I would not say that there's enough disclosure at this point. You look at an LM2 form, and certainly in order to look at the documents inside the union hall, you got to be a member. I mean, they have no obligation to give you any information. If you're exercising your rights and you're a non-member, they have no obligation to give you all that information once you're a non-member. So there's really no way to get good information about it. And the political stuff, here's what I'd say. Union officials say this, well, nobody's forced to pay for union politics. And in theory, you could make that statement because a union political action committee, their hard money, when they actually take PAC money and they give it to a candidate, that is voluntary money. But the PAC money is only about a tenth of all the political activity that they do. They're out there organizing, mobilizing, mailing, phone banks, walking streets. The union officials have a great political program, and they can use general treasury money for that type of political activity. And then you got to go in and find out what that's all about. The disclosure is very difficult. Union officials now will basically, when we file a lawsuit against them on Beck or Hudson grounds, they're usually willing to concede, 45%. They give us a number. And the last thing we want to do is make it kind of cookie cutter, because it's not. There are some unions that are extremely politically active, and they admit it. I mean, when they tell you they did, 10,000 or 10 million pieces of mail, and they knocked on 4 million doors, and they registered 400,000 people, they're doing that with general treasury money, not political action committee money. And that's where the political side comes in. But you really can't figure that out. More disclosure would be good, but I would propose to you that we don't need more disclosure. If we have voluntary unionism, then that disclosure is not necessary, because then people can vote with their feet as to what the union does. And I will tell you, in the right to work states, in Virginia, probably the strongest political force in Virginia, one of the strongest political force, is the firefighters union. But yet in the Commonwealth of Virginia, we passed a law in 1993 that said it is illegal for the government to bargain with unions. Anyone can be a member of a union if you want, and the firefighters there are strong as new rope. I'll tell you, I was at the 4th of July parade, and the AFL-CIO local came by, and they literally had 100 men and women in uniform marching. They had their families. I mean, you could sense the power of this particular organization. But the beauty of it was no one was forced to join, and the government was not forced to recognize or bargain with them as a condition of employment. But they are a very strong political force in Virginia. So while disclosure might be a remedy, kind of a stopgap till we end compulsory unionism, I hate the thought of kind of regulating it, and allowing people to say, well, we've done, we're getting this done. Like Beck. Really, in a lot of ways, the Beck decision victory in the Supreme Court for us was really a loss, because now the unions can say, well, no one's forced to pay for politics.
It just seems kind of strange unions don't have that kind of regulation. Private business does.
Yeah. Yes, sir.
The other Supreme Court decision that was made dealt with the appointments, the recess appointments.
Yeah.
I think was very, very telling where the court's mindset is to go back to the administration and say, no, I don't think so.
Yeah. Well, actually, I'm glad you brought that up, because this is a really important thing. And for this group, it's particularly important to understand what happened there. The case he's talking about is a case called Noel Canning, N-O-E-L. Noel Canning is a business up in Washington State. And they had a case in front of the National Labor Relations Board, which is this 5-member board that adjudicates labor disputes. And this case was adjudicated, and they got a bad decision. And so they came back and said that the board members, the 5 board members that decided the case, 3 of them were illegally appointed. Okay, and let's talk about this for a minute, because we have several cases. We actually argued the first case against this on unconstitutional grounds in the 7th Circuit, and the case got stayed until the district court in D.C. actually adjudicated it, and then it went to the Supreme Court. Back in December of 2011, there were vacancies on the National Labor Relations Board. 5 members, everybody serves a 5-year term. 1 person comes off every year, so you turn over every 5 years. There were 3 vacancies, and the Supreme Court had ruled that a 5-member agency like the National Labor Relations Board can't make decisions unless they have at least 3 members. There was a time during the Bush administration, George W., where there were only 2 members, and they made some decisions, and the unions took them to court. It went to the U.S. Supreme Court in a case called New Process Steel. The Supreme Court said the board cannot act with only 2 members. So the board had 2 members. President Obama then nominated 3 members to fill out the board on December 15, 2011. On January 4th, 2012, he appointed them as recess appointments to the National Labor Relations Board. So basically about a 3-week interregnum between the nomination and the appointment, using recess appointment authority. Well, first of all, there is advice and consent. The appointments clause for Senate confirmation of these people. And so there is a confirmation, there's a nomination and a confirmation process. That confirmation process doesn't require, but it generally involves background checks, like who are these people? Are they legal? I mean, we don't ask that question anymore, I suspect, but what's their background, that kind of thing. So this 3-week period, he went from nomination to recess appointment. He was using power under the Constitution under Article 2, Clause 2, Section 3, the Appointments Clause, is saying, in the recess, if a vacancy should occur during the recess, the President has the ability to fill that vacancy for executive branch people and people in the administrative branch. Well, obviously that Article 2, Section 2, Clause 3, was written when the Constitution was founded. And back then, in this utopian state that we can only dream of now, Congress only met for about 2 months out of the year. And they went home. They went back home to live with the laws that they had passed, and to plant the seeds, and to harvest the crops, and to take care of their children. And and so for 9 months out of the year, they were gone. And so if the Secretary of Defense or the Secretary of Treasury at that time passed away during the recess, the President had the ability to fill that recess until Congress came back. Okay? So the Constitution is very clear. Does anyone have a Constitution in their hand? Look up Article 2, Section 2, Clause 3. If you see it, it will be the capital R recess. Now, I'm a government school graduate, but even I know that a capital R means proper noun. Right? The proper noun recess, meaning the recess between the first session of Congress and the second session of Congress. That's what the authority was for. And so the President comes in, and this is really the scary part, and I'll get to the punchline. Give me a little bit here, because I'm fired up now. This is a bad deal. It's a bad deal. So we had 2 cases. We filed a case. We argued a case in the 7th Circuit. The judge there decided not to deal with it. He said, you guys, no reason to do that. And then there was a case called Noel Canning argued in the D.C. Circuit Court of Appeals. And a justice there by the name of David Sentell, who was a former Jesse Helms staffer, he said, well, this case is really easy. This is a case of constitutionality. And if we're gonna rule on this, let's look at the Constitution. So he looks at Article 2, Section 2, Clause 3, and what does he find? He finds that right here, let's see if I can find it here before I get to the point. Well, let's see, Article 2, Section 2, here we go. Let me get back into it. Well, it was there when I read it last. Maybe this has already been amended since the Supreme Court ruled. Yeah. But anyway, take my word for it. I can't find it right there. But here's what it says. It says the recess, the R, capital R recess. So what happens is the D.C. Court of Appeals, they rule, Judge Sentell looks at it and says, what are you asking me for? Here's what it says. This is an originalist decision. How rare are those? How unique are those? But yet, how important are those? He actually went to the Constitution and said, well, we've got our guide, we'll look at it. And he said, the President has no authority to do this. It says the vacancy must occur during the recess, and the appointment must be made during the recess, and the recess is between the first and second session of Congress. And in fact, in order to have a recess, Article 1, Section 5, Clause 4 says that in order for there to be a recess of the Congress, both houses have to agree and vote on a concurrent resolution if they're going to recess for more than 3 days. The Congress had not done that. So what the President of the United States was saying, I believe the Senate to be in recess. I don't think you're doing anything that's important, so I'm going to use my pen and my phone, and I'm going to make these recess appointments. The Senate was still in session. No concurrent resolution had been passed. There was no recess of Congress. And he ruled anyway. And so Sentell looks at that. 154 says we're not in recess. 223 says the recess. This is pretty simple. So obviously the government appeals to the U.S. Supreme Court. And what does the U.S. Supreme Court do? In Noel Canning, they rule 9-0 that the President violated the Constitution with the appointments. You think that's really good news, don't you? Yeah, that's really good news. But who was it, Paul Harvey, that said, now you know the rest of the story. And the rest of the story is important because what Judge Roberts did, what Kennedy did by switching to the majority, the 5-4 majority basically said that Article 2, Section 2, Clause 3 is no longer in effect. They said that we're relying on tradition and practice of this government because for the last 100 years, presidents have been making recess appointments and not following the Constitution, but no one ever challenged it. This is the first time that the recess appointment power of the executive branch has been challenged in the U.S. Supreme Court. First time. And when we looked at it for the first time, we said it's been violated. But the Supreme Court said, well, you know, the Constitution is kind of a living, breathing document and needs to grow with us. And, you know, they would have never considered that things were so complicated now and government was so important that they had to be in year-round. And besides, we got air conditioning. We can stick around Washington during the summer now. And so what they said is, they took the words of the Constitution and they said, it's no longer the capital R recess, it's a recess. And the tradition and practice of Congress and the executive branch has been to use recesses of what they said, well, maybe 10 days. That's an appropriate measure of a recess where the president can exercise his authority. And further, the recess doesn't have to occur during, the vacancy doesn't have to occur during the recess. So the Noel Canyon decision on its surface was a slap in the face to President Obama saying, you can't tell us Congress is in session. But what the court went on to say in a 5-4 majority with Kennedy turning the other side there, saying, we no longer care about what Article 2, Section 2, Clause 3 of the Constitution says. That's the Noel Canyon case. I mean, no one seems to dig deeper into that. I mean, the business community's all excited. Oh, yeah, we won this case. And everyone's like, oh, yeah, we beat Obama on this. But we didn't win anything. We lost ground because the court said that tradition and practice is more important than the actual words of the document.
So the admonition of when in doubt, go to the instructions no longer apply.
That's exactly the way I framed it. You got it right. This is the blueprint of how we run our government, and they said that no longer applies. The how-to never longer applies.
So are there rulings not going to be nullified?
Yeah. Basically, it's kind of hard to gauge how many, but everything that board did from that period of January 4th, 2013 until, a year later, I forget what the exact date was, all the decisions are null and void under a precedent called New Process Steel that the Supreme Court ruled on during the Bush administration when Harry Reid would not let the Congress go into recess, no concurrent resolution, so President Bush couldn't use the recess appointment power and put anybody else in the administration. Of course, this president used it, and so all those decisions are going to be redone. Most of the decisions are just simply notice postings. We've got 2 cases we're going to relitigate. We lost. We don't anticipate we're going to win them, but we'll tee them back up and then we'll get them into federal court. So they will have to do a lot of that over again. Yeah.
Locally,
Yeah.
our city council has got 3 people at the head of the union. 2 of them are just the people,
Yeah.
so we can't do anything about that. But one of our city council members is an officer in the government union.
Yeah.
Is there any rule to keep him, force him to recuse himself from any discussions regarding contracts?
I don't know that off the top of my head. I mean, certainly, in the federal government, you have the Hatch Act that stops people from running, for office. That thing. I don't know what we have to look at it. But he's an officer of the union actually is a bargaining agent for the employees, or is he from really? Oh, now that's a real problem. It seems to me, my personal opinion. We'll look at that. I'd like to talk about it. I see I'm getting the hook right now, so I need to give up this one. It's hard for me to give up a microphone, as you might be able to. I apologize.
Video services provided by Vacaville's very own Choker Films. Video production, editing, and compositing services.